Good morning, sir. You're Patrick Gallagher. And Mr. Gallagher was previously in court, entered a plea of guilty to driving while intoxicated, third or more. And I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Your Honor, yeah.
Are there any additions or corrections?
Nothing was mentioned.
I didn't see any, Your Honor.
So, Mr. Gallagher, you want to know what my big concern is? How long were you off probation for your DWI second when you got your DWI third?
I can't remember.
4 days.
4 days.
That's what it looks like to me. It expired, community supervision expired, looks like October 3rd of 2024 is the way this reads. New case, October 7th of 2024. What, if anything, have you done with regard to any kind of drug treatment? Anything on your own to stop using alcohol or drugs?
I quit drinking and I pray to the good Lord because I'm a single dad with grandkids, so that's over with.
Well, it should have been over with when you were on probation last time.
Yes, ma'am, I agree.
And I appreciate that you're praying, but sometimes that's not enough.
I agree with that too.
Are you still working
Yes, ma'am.
at Exxon?
Yes, ma'am.
Judge, there is one issue I need to bring up whenever you're done speaking.
Go ahead.
I'd spoken to the prosecutor about this. He is a full-time shift worker, and one of the issues was he had brought in his work schedule as he was, if the court was willing to, he had dates that he was not working to do the 10 days.
Okay.
And that is something that being the courts.
Sure.
Oh,
Thank you.
you weren't quick enough. You were quick though. Okay.
It was the highlighted dates is when he is not working, that he was asking the court to. I know he knows it's a big ask, but.
Well, I mean, I don't know. It kind of is. It kind of isn't. Typically, I let people who are working do it on weekends. This is just how the weekends
I have no
for his
issue
weekends.
with the erratic nature of it.
Here's the more, I guess, the part that's going to be potentially something that you're going to have to really figure out with your job schedule, and there's not going to be any excuses, is that you're going to have to enter and successfully complete the JCDI program. It is an intensive outpatient program. You're not the only patient that will have to do it on this type of schedule, but you're going to get started on that immediately without any mess ups, because if so, you're right back in here and you're going to be looking at going to prison. Do you understand?
Thank you.
So what I'm going to do then, Mr. Gallagher, is find that you entered your plea of guilty freely and voluntarily. Have you been wearing a drug patch either, or no? Was that a condition of anything? I didn't,
No, Judge. It
the
wasn't.
bond, it wasn't a condition. Well, because there was, the blood came back with positive of Delta 8 THC. I'm sorry.
That's correct.
Yeah. Are you doing anything like that still?
No, ma'am, I work for ExxonMobil.
Well, I mean, did you work for them when you,
I did, but I had a vape that I didn't know was there, so that's history.
you're 52 years old and you're using a vape that you don't know what's in it? Do you want me to buy that?
You don't have to, no, ma'am.
I don't. Because if you don't know, then you should have known. So either way, it's ridiculous that, I mean, that's something that a teenager would come in and tell me, I got a vape and I don't know what's in it. All right, I'm going to do this. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time follow your agreement, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement. Well, Actually, I'm not gonna follow the agreement with regard to the length of time on probation. The fact that he was just off of probation, I think warrants longer than a 5-year probation. The length of your probation period is ultimately up to me anyway, so, it's not like I'm following the main part of the deal, but you still wouldn't have a right to appeal, because that's up to me. So I'm going to find you guilty, sentence you to 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that and place you on probation for 7 years. You're ordered to follow all of the rules and conditions of probation. That's going to include entering and successfully completing the JCDI program, and following, obviously, all of the rules and conditions. You'll have an auto ignition interlock device on your vehicle. Do you already have that? You're going to keep that at least for some amount of time. And if he has the interlock, you can make a notation. I don't need interlock and scram and portable, whatever they feel like is best through JCDI. Once that gets going, I'm fine with. I am going to order that you serve the 10 days upfront time. That is going to be on the date starting, I'm going to attach, I'll give you this copy as well, but so like where it says 9 nights, you work that night of the 9th.
Just like I'm all
So-
right now, too.
So you'll start on October 10th. I want you to turn yourself in October 10th at 6 p.m. And then you'll spend the 10th and the 11th, and they'll release you on the 12th. Okay?
Yes, ma'am.
And then when you work days, what time do you get off?
4 o'clock.
4 o'clock p.m.?
Well, depends on when I leave, so it could be 4 to 4:30 to 5.
Okay, so the next time is going to be, since you're working days on the 16th, you're going to go at 6 p.m. on the 16th, and then you'll spend that night, the 17th, and get out on the 19th. If you don't have something written, days or nights, does that mean you're off?
And we're so short-handed, it's a possibility, or I had to work overtime because I gave up 2 days overtime already for the 11th and 17th.
Okay, if it doesn't say days or nights on this calendar, does it mean you're
Yes,
off?
ma'am.
Okay, so that second one in October, you're gonna go, we're gonna get this done. Because that's your long days off, so we're gonna get that week all done. So you're gonna go in on the 16th, and you're gonna get out on the 23rd. So that gives you 1 overnight, 16th, 17th, 18th. That gives you 7 days. And then that first one only gives you 2 days, so that's 9.
So you're saying go in on the 16th when I get off work that day?
Mm-hmm.
Okay.
We're just missing 1 day.
There's 7 November on the back of it there.
No, we're getting this will be done in December, so you're gonna then go in on the 28th
Yes, ma'am.
at 6 p.m. and you'll get out the next day, and I'll take care of that last day. So, and then Anna will probably need that too. Make sure you get all of those done. Okay,
Thank you.
all right. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rennick. You need to have a seat here in the courtroom and wait for probation to call you up. She'll call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Yeah. What was it? $500 fine is obviously part of that as
Yes,
well.
sir.
Yes.
Thank you, Your Honor.
Emily, thank you, Mr. Nichols. Emily, Mary Lockard Fury, cause numbers 24 DCCR 1374, 1905, 1906, and 1907.
And Judge, I brought something, Judge, this has been the one with federal
Yes.
issues.
Mhm.
And we had a proper meeting with the feds in early September, late August, for a day. I had informed them that this needed to be wrapped up because of what you had expressed to me in our last meeting. They have followed up with me and said that charges are imminent. And Judge, just to be very straight with you about it, they had told me that in June. And then I'd said, I'm getting heat respectfully from the courts, and she has charges also pending in chambers in Hardin County. The courts are aware of what's going on. Mr. Moran, the assistant U.S. attorney, has informed me that he thinks it's going to happen either, he alluded to me it's going to be in October, but I have no way of telling the court with absolute certainty that's correct. I don't have any control over it because I thought it would be sooner.
Right.
But the dilemma for me is, and Mr. Smith, who's been super helpful and accommodating dealing with this issue, is that we know that the federal charges are coming. They haven't landed yet. But I don't want to be placed in a situation where I have to clean the state charges and the federal charges are coming. That's why I brought that email. So
I appreciate the email. If you don't mind, I'm gonna hang on to this.
absolutely.
I might give Ray a quick email or a
Yeah,
call
and
just
he's
to
very-
find,
he's very
I've known him
pleasant.
we used to work together, so I'm fine with,
I've spoken with him, I've sent him all of the restitution amounts for our cases.
yeah. And he's probably, he may be waiting on other,
We had like a 6-hour proper meeting with the U.S. Attorney's Office. We have nothing else to give them.
Right.
We give them everything and everything. It's really just waiting for, he's claiming a debriefing and the charge is coming, but it's taking
okay.
quite some time.
I'm going to do, let's do 45 days, reset, and then I'll email him or give him a call
Yeah, I learned
and just see if
something.
he can, if maybe that helps, or at least I can find out if it's, that they're waiting on maybe other agencies that y'all don't have any, or you don't have any access to, if there's other counties involved.
In the first email that's on there, you might notice that I was getting feed from Jefferson County, but it sees Judge West.
No, I saw, I saw that. No, I'll give him a call and see if I can get some more information, and then we'll hopefully get some answer between
If
now
I
and
know
then.
anything, I'll phone report.
Okay, thank you. All right, you're free to go. 45 days. Thank you, Mr. Rennick. Mr. Weston, Mr. Wilkerson, Mr. Cole, Mr. Adams. See, Mr. Cole, you have Leonard Idlebird.
Yes, Your Honor. It's correct.
But, you know, I was in here last week and flagged this.
Oh, that's okay. I think it might help just to others to know what's going on too. Would you put a sticky on that and then put it on my desk just to remind me to do something with it, please, ma'am? Good morning, Mr.
Good
Cole.
morning, Your Honor.
Good. Good morning, sir. Are you Leonard Idlebird?
Yes.
This is cause number 16-25968. It's the MTRP. I feel like we're waiting on, there was a motion for a competency evaluation,
Yes, ma'am. I e-filed the
but I don't see that it's been done yet. Has,
it's been done.
it has, we just
Yes.
don't have a report yet.
It should have been e-filed into the case, Your Honor.
The report,
Yes, Your
they
Honor.
sent it to you?
Yes, Your Honor.
Oh.
Not to me, not to you.
Oh,
I mean,
okay.
I certainly take
Who
Mr.
did
Cole's
it?
word for it, but
Dr. Riggins out of Houston.
Oh,
The court wouldn't pay for his evaluation.
I don't see that it's in here yet.
I do have a copy of it.
Can I see it real quick?
I'll have to send it to your email, Your Honor.
Oh, okay.
Yes.
All this paperless stuff.
Yes, Your Honor.
Finding competent, not competent?
Not competent.
Okay,
not competent or
Dementia.
dementia,
Dementia.
because I think there's a legal difference.
Yes.
yes,
Yes, it was dementia.
okay. Obviously, we need to take a look at that. I'm gonna reset it 2 weeks.
That sounds great.
If you will make sure, it should, if you e-filed it, it should be coming through, but if you'll also just in an email forward that report to
will.
Ms. Malfino and I,
Yes.
and that way you guys can take a look at it, talk and see if there's something that you can work out. I can look at what my options are with regard to that diagnosis, and then we'll see where we are in 2 weeks.
Judge, just so the court is aware, I spoke at length with his probation officer, Ms. Hunter, last week. Previously, when we were here, I believe back in June, you ordered that he not drive. and you spoke with his wife here in
Yes,
court.
yep.
Ms. Hunter relays that he is complying with all that. She
Okay.
actually comes to his appointments
Good.
with him, and that everything seems to be
Okay.
going well with respect to that condition.
Okay, well, maybe we'll be able to work it out with just modified type probation, we'll see. Okay, all right, we'll see you in a couple of weeks. Mr. Gertz, you've got David Hatcher. Morning.
Judge, how are you?
Good. How about you?
Well, I'm good. Excited about this week.
Oh, me
Aren't you
too.
excited?
I'm so excited.
I can see it all over your face.
Yeah. Good morning, you're David Hatcher. And this is 24 DCCR 2470. I have a memo that this was the last reset for an announcement.
There's a rejection I just forwarded on, Your Honor.
Oh,
And it's pretty non-specific. Any offer that was gonna be made is gonna be a pen time offer. So
okay. Let me get that
We
pulled
were
up.
looking for something vastly different than that, so.
All right,
we're on the
so
same page.
you're David Hatcher. And Mr. Hatcher, you're charged with a third-degree felony offense of intoxication assault with a vehicle causing serious bodily injury from September 24th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment could be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection that you've signed with Mr. Gertz that just shows that any offer the state would make would be for prison time and not for a probation. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, anything that you guys are waiting on discovery-wise?
Not that I know of. Discovery.
I'm not aware of anything discovery-wise, Judge.
All right, we will get it set on the next available trial docket. Stay in touch with Mr. Gertz. He'll let you know when you need to be back. Thank you. You're
Thank
free
you,
to
Your
go.
Honor.
And Christopher Thomas, Mr. Gertz.
Judge, we'll meet Ashley back for that.
Did she step out? Did which way did she go?
This is important, so.
Just have a seat for a second. I'll recall it in just a second.
Thanks, Judge, sorry.
Mr. Kelly, you've got Donald Owens.
He's present.
Good morning. You're Donald Owens. And this is 24 DCCR 1192. Mr. Owens is charged with sexual assault of a child, set for trial to begin with jury selection next Monday. And what is the announcement?
Stay true.
All right, then I want to make sure that y'all all understand, obviously after today, no plea agreements unless there is something that comes up very quickly that I'm not or y'all aren't aware of. It is likely to be towards the top of the list since the other old one is gone now. So stay in touch with Mr. Kelly. He'll let you know when you need to be back next week. Okay? All right, you're free to go.
Thank you, Judge.
Thank you. See, Mr. Lewis, you have Naquindon, oh, there you are. Naquindon Acklese.
Yes, Judge.
Good morning, you're Naquindon Acklese.
Judge, you're gonna ask me this in sentence, I'm gonna explain now. The reason it's now a probation offer, instead of a 10-time offer, which originally was based on his criminal history, because he had done a 10-year stretch for robbery, starting in 2014. Really, I'm rewarding him because he's tested clean every time since about this time last year, Your Honor. And he's come to court, he's done what the court's asked him to do as far as trying to hire an attorney. I think he ended up still having Mr. Lewis appointed, but I know that he's done everything the court's asked him. Essentially, I'm rewarding him because he's tested clean ever since September of last year.
Okay, thank you. I need your signature. And are we going on count one only?
Yes, Your Honor.
Okay, you're Naquinda Niclease,
Yes, ma'am.
and will he waive the formal reading of the indictment?
He does, Judge.
Mr. Eclese, in cause number 24, DCCR 0478, the state has elected to proceed on count one only. It alleges you committed the second-degree felony offense of burglary of a habitation from February 5th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak up, please.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Eclese is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Obviously, you've been doing very well and following all of those bond conditions. Continue to do that. You shouldn't have any issues. And then we'll see you back at sentencing. You need to stop on your way out of the courtroom today and talk to probation, and she's at that desk right there. Okay, we'll see you back.
Thank you, Your Honor.
Good morning. Are you Karis Antoine? And will your client waive the formal reading of the indictment?
He does, Judge.
And I'm guessing there's a warrant for what?
His bondsman surrendered his bond.
Okay,
And honestly, we thought it was something that was taken care of. They had contacted me. I actually got in touch with Mr. Antoine. He spoke with him, but
okay,
Yes, because I talked to him Friday and
okay. That's good. I just wanted to make sure. You're good. Okay. And he'll waive the formal reading of the indictment.
he does, Judge.
Mr. Antoine, in cause number 24, DCCR 1878, you're charged with the third-degree felony offense of injury to a child from September 26th of 2023. And how do you plead to that charge?
okay, good.
You either did it or you didn't do it. Guilty or not guilty? Are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Antoine is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report, and that'll give me more information about you and your case, and then we'll come back later for sentencing. So, with regard to a bond based on the nature of the plea agreement, Mr. Nichols,
I don't have any objection to that, Judge. He has no felony history that I see.
right? Let me look at this affidavit real quick.
The charge itself is for hitting a child with a belt, over discipline essentially.
Okay. What's the status of that relationship? Do you still live with that child?
I haven't been around him since the case went on. When I
Okay.
do see him, I see him with my mom.
Supervision.
Her mom.
Okay.
And I really miss my family.
Well, and we'll see how that goes on probation. For now, you're still under that order to have it only supervised, okay?
I understand.
And then you can work up, once you're on probation, hopefully to doing the right classes and everything, and that should be lifted. What I'm going to do, Mr. Antoine, is reduce your bond in your case to $1,000, and I'm going to make that a personal bond. So I think that means, though, that he still has to go, right? Okay, so you're still gonna have to go, but as soon as you get to the jail and they process you, you're going to be released without making that bond that I set because of the bondsman getting off your bond. Okay, makes sense? It's just, but here's the thing. I'm kind of putting myself out there to make sure that you're gonna do all the right things between now and sentencing, okay? You have been until then, but it looks like you had some issues at some point communicating with your bondsman. It's very important, several things that you have to do between now and when you come back for sentencing.
I got you.
Once you're released from jail, you're gonna get some paperwork today. It's gonna have where probation is. You have to go straight to the probation department, okay? If you get released for some reason later this afternoon and it's too late, then you go first thing tomorrow morning. If you don't do that and get that process started for that pre-sentence report, I don't have to accept this plea agreement. So things could be a whole lot worse. Do you understand? If you violate your bond condition and you're around the children or child that you're not supposed to be unsupervised, then obviously I don't have to accept this. Things could be worse. So keep following all of the rules of your bond. Yes.
I have one question. Okay, is it only for that child?
No, I would say at this point, it needs to be all of your children, and then we'll deal with everything when we come back for sentencing, okay? And so that's for everyone, just to make everybody, well, it's not for everybody, it's for me to feel more comfortable until I get the pre-sentence report and I see what all is going on, how many kids you have, where they live, what the situation is, what the recommendations are from probation. So we're only talking about 5 or 6 more weeks.
Yes, ma'am.
But it is
I really have something important to tell you.
What?
I've been raising my 10-month-old for months by himself. So if I have to give him up, I will, because I need to start looking for my kids.
Well,
He's a baby. He's been with me since 12. Like,
where's the mom?
we don't talk. Since the case going on, we don't talk like that. Like my mom and her mom, that's when we meet up. But
I think the court's question is the mother of the 10-month-old the mother of the child in this case?
yes,
So where's the child that was in this case live?
she's with her mom. I don't see them like that. Like we've been separated since I had been arrested, and she stayed with her mom, and I have my own place.
Okay. But it's the same mother of both of your children,
Yes, ma'am.
but the baby lives with you
Yes, ma'am.
and the other child lives with her.
Yes. She got 4 other kids live with her. I just got one.
Did you go through anything with CPS as far as they were, I mean, we have an order for some CPS records, but was there anything to CPS get involved?
No, ma'am, I never went through nothing like that.
Okay,
I don't think anything's been provided to us in response to that order.
it doesn't
Judge,
look like it.
maybe
So maybe
there's-
that's because there wasn't anything.
Yeah.
I think it was important that I tell you that I have.
No. I would much rather you be honest, but, and if you're raising, let me look at something real quick.
No, not at all.
Yes, just and just to clarify, the child is, in this case, not his biological child.
Okay, so how many biological children do you have?
3.
No, with her.
Oh, 1.
Just
One with that, where you, and then the other 2, or where are they?
They're all with her, and Oh, my other two, they're with their moms.
with their moms.
Yes, ma'am.
So this is the only one you have. So there's no big deal. I mean, obviously, you love your stepchildren, but that this isn't your own biological child that's the
Right.
subject of this case.
Right.
Okay. Then what I'm going to do as a condition of your bond is order that you not have unsupervised contact with all of the children except the one that you're raising. Okay. If you're raising that child, I'll allow you to continue to do that. You'll get out, make sure that you follow all of those bond conditions. The last thing I was going to tell you is that as a condition of this, if you are arrested for anything between now and when you come back for sentencing, again, I don't have to accept this agreement. Things could be worse. You understand? Okay, we'll see you back at sentencing.
Thank you, Your Honor.
Thanks, Judge.
Thank you. It's no contact without supervision except for the 10-month-old. Mr. Lewis, you have a sentencing with Shay Brooks.
Yes, ma'am.
Sentencing. Good morning. Are you Shay Brooks?
One shot.
Shy, and Mr. Brooks, in cause number 24, DCCR 2034, was previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle, received the pre-sentence report. Has everyone had an opportunity to review the report?
Go ahead, Judge.
State has, Judge.
Any additions or corrections?
Nothing, Judge.
Nothing from the state, Judge. We just ask the court follow the reading of the party.
Thank you, sir. All right, Mr. Brooks, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you to a term of 10 years in prison, but probate that for a term of 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have the felony conviction. Well, no, it's not. I'm sorry. You do have, for all practical purposes, your case here in court is over if you do everything you're supposed to. And you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 10-year sentence that you've already agreed to. Do you understand?
Yes.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you. Thank you.
The courtroom was tense as repeat offenders faced the consequences of their past actions. Patrick Gallagher, previously on probation for a DWI, entered a plea of guilty to his third DUI. From the start, the judge questioned his excuses, noting he had only been off probation for 4 days before committing the new offense. Gallagher tried to defend himself, claiming he had quit drinking and prayed daily, emphasizing his role as a single dad with grandchildren. "Sometimes prayer isn't enough," the judge responded, immediately signaling that excuses would not sway the court. Gallagher's Delta 8 THC vape story further enraged the courtroom. He claimed ignorance of the contents, a defense that fell flat. "You don't know? Then you should have known," the judge said, cutting through his story. In the end, Gallagher was sentenced to 10 years in the Texas Department of Corrections, suspended, and placed on 7 years probation with strict requirements, successfully completing the JCDI program, following all probation rules, and installing an ignition interlock device. The judge explicitly warned, if you mess up, you go to prison. Meanwhile, Naquinda Knowles, a burglary offender, and Karis Antoine, charged with child injury, had their cases carefully reviewed. Knowles had followed all prior court instructions and tested clean for drugs. The judge rewarded this compliance with probation instead of prison, but emphasized strict adherence to the bond terms. Antoine's bond was reduced to $1,000 personal, yet the judge stressed he could not have unsupervised contact with all children except the one he currently raises. Each case illustrated how small compliance or violations could drastically alter outcomes, creating high suspense for both defendants and viewers. Shay Brooks' evading arrest case followed a similar pattern. Though sentenced to 10 years in prison, it was fully probated, giving him a chance at redemption, but with a strict warning: any probation violation would trigger immediate imprisonment. Across all cases, the judge maintained control, demonstrated keen legal knowledge, and delivered justice with dramatic timing. The defendant's reactions ranged from stunned silence to emotional admissions, creating a highly charged, suspenseful courtroom environment. This series of cases highlights a crucial lesson. The legal system is precise, unyielding, and observant of patterns. Excuses, prayers, and ignorance carry no weight against strict legal procedures. Viewers witness the interplay of accountability, mercy, and stern justice, with each judge's decision demonstrating how probation, compliance, and prior criminal history determine life-altering outcomes. The courtroom's tension, the defendant's shock, and the judge's unwavering authority make this real-life drama unforgettable.